Okay, sir. Now I request Vivek sir to restart the session. Sir, you are on mute mode.
Am I audible? Rupali ma'am? Am I audible? Am I audible? Rupali ma'am?
बाद में बात करेंगे रियन, मैंने बोला बिजी, मैं बाद में बात करूँ. हेलो सर, आपकी वॉइस आधी ऑडिबल.
Okay, fine. Ma'am, my PPT is visible or no? Ma'am, my PPT is visible or no?
सर, आपकी वॉइस ऑडिबल है.
Ma'am, my PPT is visible or no?
बट सर आपकी पीपीटी विजिबल है, आप थोड़ा सा लाउडर बोलिए सर.
Okay, fine. Okay, fine. Honorable Director, IIMT College, Professor SSS Tyagi ji, respected IIC President, Professor Sanjay Pachori ji, coordinator of this event, Professor Rupali ma'am, all the dignitaries and dear students, a very good noon to all of you. Before I start my today's talk, I would like to say congratulations to Professor S.S. Tyagi ji and IIC President Professor Pachori sir and his entire team for getting 4 out of 4 by our college IIC As we all know, many IITs and other reputed institutions in India didn't get good score like IIMT College, Greater Noida. In today's talk, I will deliver my talk on patent filing awareness. So, in today's talk, I will cover different key points of patenting. For example, I will cover brief introduction about patent, then geographical reach of patent, and then I will discuss what are the different type of patent applications by which you can apply for the patent in Indian IPOs. After it, you all will see IP, IPR, and IPR laws in India. After it, I will give you practical demonstration of IP. Then you will see what are different IPOs in India, and then we will discuss trademarks, copyright, GI. Along with it, we will discuss very important key topic, patentable subject matters and non-patentable subject matters. After it, I will give you some exposure on drafting and application process of Indian patent and international patents, right? So these are the some key points for today's talk. So my friends, let's begin from the patent. Patent is a legal, exclusive legal rights which is given by the government of India to the inventor. This is for the disclosed invention, and this patent is only limited period of time. From the perspective of India, it is only for 20 years, and this period vary from country to country, right? If you are filing your patent in India and somehow your patent is granted, then your patent, or you can say it is only enforced only within the territory of India. Enforced only within the territory of India. Suppose if you have some novel idea, or if you have done some experimental work, or if you have developed some process or product, and your product or process satisfy all these three conditions. First is novelty, second is inventive step, and last is your invention have some industrial applicability, right? If all these three conditions are satisfied, then you can look for the patent, or you can prepare your technical or legal drafting process. So after preparing your legal documents related to your invention, you can file your patent in Indian IPOs. And if somehow your patent is granted at Indian IPOs, then you will get a mutual agreement in between Government of India and inventor. And this agreement is only valid for 20 years in India. If your invention is granted in India, by in your hand, you can sell or you can earn money by your patent, right? Your invention is granted in India. By As you all know, in India, patent is only valid for 20 years from the date of application. And after 20 years, your patent will come into public domain. That means anybody can use your invention for their work without taking prior permission from the inventor. Okay. In patent must disclose the best way of making and using inventions. Very essential condition for the patent. You must disclose everything related to your invention in your patent application. Geographic reach of the patent. Generally, patent rights are limited territorially. An Indian patent is limited to the territory of India. If you are going to file your patent in India, it will only be enforceable within the territory of India, not outside India. If you are going to file your patent in Australia or in China, your patent will be only enforceable within the territory of Australia An Indian patent cannot be enforced outside India. Suppose if your patent is granted in India and it will not be enforceable within the territory of Pakistan, Australia, China, etc. There are different field of invention, or invention can take place in any field, whether it is electronics, computer application, communication, biotechnology, microbiology, biotechnology, nanotechnology, Ayurveda, and Siddha. So invention can take place in any field. You can develop any process, any method, any algorithm, any device, anything which is valid under Indian Patent Acts, which satisfy certain rules under Indian Patent Act 1970s. So, in essence, we can say invention can occur from a safety pin to a satellites, or we can say invention can take place from a nano scale to a very large scale. This is very essential or important topic, patents applications. If you have some idea and you are looking for the patents, so this is a very important topic for all of you. There are different type of patent application. First is ordinary application. In ordinary application, we have provisional specification application, and the second we have complete specification application. First, let's discuss what is provisional specification application. Suppose if you have some idea, or if you are working on your experimental work and your work is not completed, but your idea or your invention is novel, or it satisfies all the technical conditions which are related to Indian Patent Act. So if your work is not complete, in that case, you will choose this kind of application, that is ordinary provisional specification application, right? After filing your provisional specification application, you will get 12 months time to complete your work. If somehow you will be unable to complete your work within 12 months, so after the completion of 12 months, your application will be rejected, right? So this is all about provisional specification application. Next, you can see complete specification application, or you can say ordinary complete specification application, right? For example, if you have some idea and you have completed all the work related to your invention, in that case, you can choose complete specification application, right? Next, we have convention application, an application for patent filed in the patent office claiming a priority date based on the same or substantially similar application filed in one or more of the convention countries is called a convention application. In order to get convention status, an applicant, or you can say inventor, should file the application in the Indian Patent Office within 12 months from the date of first filing of a similar application in the convention countries, right? So this is about convention application. Next, you can see PCT, International Phase Application, or in short, WIPO. This is one more important type of patent application. PCT stands for Patent Corporation Treaty, is an international patent law treaty. This is concluded in 1970. It provides a unified procedure for filing a patent application to protect invention in each of its contracting states. A patent application filed under this PCT is called an international application or PCT application, right? WIPO means World Intellectual Property Organization. If in PCT, it's a, you can say, treaty of different countries. They all come together, sign a agreement. If you are looking for the international patent, you can file directly at the WIPO office. For this, you have one more option. If you directly don't want to file your application in WIPO office, you can choose Indian WIPO method. for example, you have fourth option, that is PCT national phase application. In Indian IPOs or Indian Patent Office, you have option for this. If you don't want to direct file your patent at international level, you can choose another way, that is PCT national phase application WIPO. You can file at WIPO by using Indian IPO also, right? Next, we have patent of addition application. Suppose earlier you have filed an application for your invention, but after some time you realized you want to do some improvement or some modification in your application. In that case, you can choose patent of addition application. So by using this application, you can modify your previously submitted application as per your preference, as per your choice, right? I'm audible. I am audible.
Yes, sir, you are audible.
Okay, ma'am. Next, we have divisional or parent application. Suppose earlier, if you have earlier submitted an application in which you have described about two or three inventions, but after some time you realized you want to separate out those two or three invention in different application. So for that case, you will choose divisional or parent application. So this is all about patent application in Indian IPOs. Next, intellectual property. Intellectual property is an outcome of human brains, or you can say intellectual property is the creation of human mind. Okay, if you think some creative and by which you can earn money or by which you can get some return, whether it is related to some industry, it is related to scientific or literary or artistic work. So all these type of work, or you can say all these type of intellectual work which is created by human brain is come under the category of intellectual property. And for the protection of such intellectual properties, government developed some rules or laws for the protection of such intellectual property. So such type of rights for the protection of IPs is called intellectual property rights. Now come to the IPR laws in India. Generally, industrial IPR laws are administered by the Department of Industrial Policy and Protection and Controller General of Patent, Design and Trademarks. If you have developed some method, some process or some device, that will be registered under the Patent Act 1970, right? Next, here you can see this is a Trademark Act 1999. If you are making or you are developing some trademark, that will be registered under the Trademark Act 1999. In trademark, there are many things. For example, words, sound, logo, some tagline or slogan. So all these things are related to trademarks. These things will be registered under the Trademark Act 1999. If people belongs to electronics background or physics background, or anyone who have looking for the development of semiconductor ICs, so all such work will be registered under the Semiconductor Integrated Circuit Layout Design Act 2000. Next, you can see GI Act 1999. If any product which is famous from any particular region of the country, so peoples from that particular region can register their product under this GI Act 1999. Next, we have a Design Act 2000. If anybody is making some design or developing some geometrical shape, whether it is some four-wheeler or two-wheeler design, so such type of invention will be registered under the Design Act 2000. Next, here you can see Copyright Act 1959. If anybody is making some artistic or literary work, that will be registered under this Copyright Act 1957. As we all are educator, if some professor is writing a book, so before publishing your book, you must take first register your draft under the Copyright Act 1957. Because if you are directly sending your draft to the publisher, so after receiving your draft, publisher first take the copyright for your work. So for that case, if you want to change something in your book, you cannot change, because the copyright for your book is in the hand of publisher. So without taking prior permission from the publisher, you cannot change anything in your book. So before publishing your book, you first take copyright for your book, then you can send your book for the publication to the publisher. There are several other IPR laws which is administered by the other ministries. For example, Ministry of Environment and Forest. This is taking care of biological diversities, and that is called Biological Diversity Act 2002. Next, we have Department of Agriculture and Cooperation. This is basically taking care of protection of plant varieties and Farmer Right Act 2001. So all the things which is related to the plant varieties and farmer related things come under the category of these ministries. This is a practical example of intellectual property. If we talk about the conceptual features of this pressure cooker, so the conceptual features of this pressure cooker will be registered under the patent right. If you are talking about the design or the geometry or shape of this pressure cooker, so that will be registered under the Design Act. So you can say design of this pressure cooker is the intellectual property. Next, if you are talking about the catalog, booklet, or the manual for this pressure cooker, so that is a copyright intellectual property that will be registered under the Copyright Act. Suppose this pressure cooker over here, you can see this is some logo name. Here you can see over here. So name, logos, all such type of things will be registered under the Trademark Act. So this is all about IP. This is one more example of cell phone. The working mechanism of this cell phone will be registered under the Patent Act. If you talk about the shape and geometry of this cell phone, that will be registered under the Design Act, or you can say it's a design intellectual property. Next, here you can see this is some logo of Motorola company, you can see, or some symbol or some tagline or slogan of any company, that will be registered under the Trademark Act. Next, here you can see manual. If the working manual or the some booklets related to this cell phone, or where you read all the instructions how to operate cell phones, so such type of manuals or booklets will be registered under copyright. Now we have IPOs in India. Here you can see many IPOs in India related to different IPs. First, you can see PPVFRA, Plant Protection and Variety of Farmer Right Act. Registry office is situated in Delhi. If somebody is working on the semiconductor ITs, so he or she can contact on SICLDR Registry Office, that is Semiconductor Integrated Circuit Layout Design Registrar Office, which is situated in Delhi. Next, we have RGNIIPM, that is Rajiv Gandhi National Institute of Intellectual Property Management. It's basically a training institute. If you want to take more exposure regarding patenting, you can go there, you can attend some courses, workshop there. It is situated in Nagpur. Next, which is very important, here you can see patent office. If you are looking for the patent, you will go in these four offices: Mumbai, Chennai, Delhi, Kolkata. And Kolkata is the head office for patent. Next, here you can see design wing. Design wing or you can say design registrar office is situated in Kolkata. If you are developing some design, you have to contact Kolkata Design Registrar Office. Next, here you can see Trademark Registry Office. The head office is situated in Mumbai. And other four more offices are, one is in Delhi, other in Kolkata, Chennai, Ahmedabad. Next, Geographical Indication Registrar Office, it is situated in Chennai. National Biodiversity Registrar Office situated in Chennai, and Registrar of Copyright, it is in Delhi. So this is all about the intellectual property offices in India. Next, property. Property are basically of two types. First is tangible property, other is intangible property. You can see, you can touch the tangible properties, but you cannot touch or you cannot see the intangible property. Tangible properties again of two types. One is movable. Movable tangible property are those property by those property which are movable in nature. For example, laptop, cell phone, table, chair. So these things are come under the category of movable tangible property. You can see them, you can touch them. Next is immovable tangible property. You can see them, you can touch them, but they are immovable in nature. For example, land, some plot, flat, house. These are immovable tangible property. Next, here in the second group, you can see intangible. All the intellectual properties come under the category of intangible. That means you cannot touch the intellectual property. So we all know all the intellectual property are the creation of human brain. It is the outcome of your thoughts when you when your thoughts are very novel or have some industrial applications. So your ideas are your intellectual property. Trademark. So these are the some example of trademark. Here you can see trademark can be a word, expression, sound, letters, words, names, number, expression, logo, hologram, smell, combination of colors, many things. Here you all I think listen the ringtone of Nokia, Airtel. So these all are the trademarks, sound trademarks. You all see some letters trademark GM, BPL, Fiat, Bata, Intel. So these are the letter trademarks. Next, you can see words trademarks, Apple, Idea, names trademark, Usha, Tata, Ford, Samsung, Nikon. Next, 471, it's a perfume brand, very famous perfume brand. Next, you can see expression trademark, LG, Britannia. And last, logo of Mercedes, Nestle. This is the logo of Oxford University. I think IMT also have logo registered under trademark. Right. There are some more example of trademark. Google, Microsoft, Walmart, IBM, and there are so many examples which I have taken for this slide. You can see if you are changing already existing trademarks, it will not be acceptable. Suppose if you are writing Walmart, instead of Walmart, you are writing Mart Wall. So it will not be acceptable in India under Trademark Acts. If you are developing or making some artistic or literary work, so these all things come under the copyright. So for your artistic and literary work, you can take copyright for your work. Next, we have geographical indication. If any product or any thing which is famous from some specific or particular region of the country, so the people from that place or group of people from that place, they can take GI for that product. For example, here you can see some national or international GI. First is Darjeeling tea. This Darjeeling tea is associated with the West Bengal. So peoples from the West Bengal, they have taken GI for Darjeeling tea. Next, you can see Mysore silk. It is associated with the Karnataka. So group of peoples from Karnataka, they have taken GI for Mysore silk. Next, you can see Kullu shawl. It is associated with the Himachal Pradesh. Next, you can see Madhubani paintings, very famous. It is related to Bihar, Feni, Tirupati Laddu, Bikaneri Bhujia, Fulkari, and so on. Agra ka Petha. There are many things which are famous from different parts of the country. Here you can see some international products, Havan cigar, Scotch whiskies, associated with UK, tequila, Mexico, Swiss knife connected with the Switzerland, and so on. Here you can see Irish ice cream. It is associated with the Ireland. So peoples from the Ireland, they have taken GI for their Irish cream. Here you can see. Next, patentable subject matter. Invention must relate to a process, product, or both. Invention must be a novel. It involves some inventive step, or you can say it must be non-obvious. An invention must be have some industrial or social application, and it does not fall under the section 3 and 4 Indian Patent Act 1970. So before filing your patent, you must check all these conditions which are mandatory for the patent granting. If these conditions are not satisfied at the initial stage, so at Indian IPOs, your application will be rejected if these conditions are not satisfied. Right. Next, new. First condition is new. That means novelty. So you first check on the Google, or you can do some homework or check it on other various portals whether it is published in India or elsewhere. Or you also check whether your invention is in public domain or not. Or you also must check on Indian IPO's website whether it is claimed in claims in any specification in India. Okay, so you have to take care of all these things. Next, inventive step. Your invention must have some novel step, or you can, in other words, we can say any average skilled person from your field cannot think about your work. If your invention have 8 or 9 or 10 steps, so out of 8, 9, 10, at least 2, 3 steps should be inventive or very new to all. Non-patentable invention. As per Indian Patent Act 1970, under Section 3A, all the frivolous inventions and inventions contrary to well-established natural laws are non-patentable inventions. For example, if anybody says sun rise in the south direction, so this is against the natural laws. Okay, a machine which is alleged to give output without taking any input, so this is against the natural laws. So only making in one piece articles previously made in 2 or more pieces is frivolous. So such type of work are non-patentable inventions under Section 3A of Indian Patent Act 1970. Next, Section 3B of Indian Patent Act. Commercial exploitation or primary use of inventions which could be contrary to public order or morality. So such types of inventions are not patentable invention. For example, human cloning, device or method for committing theft or burglary. So such type of work is not patentable invention, non-patentable invention. You can take one more example. If any student is developing a device by which he or she can do cheating during examination, so such type of invention are against the morality. So such type of work or invention are not patented in India. Invention which cause serious prejudice to health, human, animal, plant life, or to the environment. Or in other words, we can say any invention which negatively affect to human health, animal health, or life of plant, or it also have some adverse effect on environment. So such type of inventions are not patentable. For example, any method or process or device for the adulteration of food are not patentable. If anybody consumes such type of adulterated food, it may cause some serious disease. Next example, method or device for mass destruction of plant or animals. So these all are not patentable under Section 3B of Indian Patent Act 1970. Next, Section 3C of Indian Patent Act. mere discovery of scientific principles, formulation of an abstract theory, or discovery of any living thing, or discovery of non-living substance occurring in nature. For example, Newton's law, Darwin's theory, discovery of an animal, discovery of natural gas or a mineral. So such type of discoverable things, theories, principle are not patentable in India under Section 3C, right? So there is a small difference in between discovery and invention. In discovery, we find the new thing which are already existing in the nature, but in invention, we find the new thing. We develop the new method, new process, new device which are not existing in the nature, right? So it's a very small difference in between discovery and invention. Next, next section is 3E of Indian Patent Act. If you are mixing any known to substance and they have some different outcome and the resulted product has some different nature or characteristic, so such type of work or such type of invention are not patentable. For example, you know paracetamol have antipyretic nature and brufen have analgesic function. But if you combine these two, paracetamol and brufen, it become a combiflin. So such type of mixture or addition of two or three known things are not patentable invention, right? But if a mixture resulting into a synergetic properties of mixture of ingredients, however, may be patentable. For example, if you are making soap, detergents, any lubricants for two-wheeler, four-wheeler, or such type of mixtures are patentable under Section 3. Next, we have Section 3H. Method of agriculture or horticulture are not patentable invention. For example, cultivation of algae, mushroom, sugarcane, wheat, rice are not patentable. If any farmer is preparing a soil by which he can increase or enhance the yielding capacity of the field, so such type of work are not patentable in India. But if anyone or any farmer is developing some tools or some equipments for the agriculture, they are patentable under Section 3H of Indian Patent Act. Next, we have Section 3F. Only arrangement or rearrangement or duplication of known device which are functioning independently, they are not patentable invention under Section 3F. For example, a bucket fitted with a torch, they are not patentable because bucket have right. Next, we have one more example, an umbrella with a fan. Umbrella and fan both work independently. They don't have any correlation in between them. So such type of arrangement or rearrangement of products or things or device or product are not patentable under Section 3F. Next, IP evolution. If you have some idea and you can express, so it is a copyright IP or you can register it under Copyright Act. If you have some your idea in your mind and you can do some innovation for that, and after it you do some invention, so it is a patent IP. It will be registered under the Patent Act. But if you have some idea which have quality as well as some identity, so such type of idea which are having quality as well as identity can be registered under trademark. Next, if you have an idea and your idea have some appearance, you can visualize it in some geometrical shape, in some design. So it's a design IP, or you can register your idea under Design Act. Last, which is very important, this is related to business. You have some idea and you want to keep it confidential, you don't want to disclose in front of anyone. So you can register it under trade secrets. Okay. Self-evaluation of invention. If you have some idea in your mind, so before filing patent, you first check three essential conditions: whether your invention is novel or not, it is non-obvious, and it has some digital application or not. And after checking these three conditions, you should check whether your inventions may fall under these sections of Indian Patent Act 1970, which we have just discussed. If your work fall under these sections, it will not be patentable in India, right? After checking all these things, you can do Google for your work or your invention, or check whether this is published in anywhere or not. If it is published anywhere or if it is in public domain, it will not be patented in India. General process of patent is, first you will file your application for your invention for your patent. After few days or few months, your invention will be published, or it will be available on Indian IPO's website. Here you can, I will show you after the few slides. Next, after publication, your application will face next phase, that is examination. And after completion of examination, your invention will be granted, or you can say you will get a mutual agreement in between you and Government of India, or you can say certificate of patent granting. And the fourth is commercialization. If your invention is granted, you can do commercialization for your invention. You can give it to any industry, or you can take a rent, or you can take any commission. In short, we can say you can get some return under commercialization section from your invention. These are the top 10 applicants for patents from different institutes and universities. This is the last year data. Here you can see all the collective IITs filed for 100 application. MIT University on the second rank, ISC in the third. So this is the last year data. Now come to the very important part of today's talk. Am I audible or not? Am I audible or not? Rupali ma'am? Am I audible?
Hello?
Ma'am, are you getting my voice?
Yes, sir.
Okay, fine. Okay, fine. Now, this is a very important topic for today's talk: drafting and application process for the patent. First is mode of application. There are two modes for the patent filing. First is offline and the second is online. So as per your choice, as per your preference, you can choose any one of them. You can go for the offline or for the online mode, as per your choice. Next, if you have some idea, or if you are completing your experimental work and now you want to prepare the draft for your application, for your patent application. So for that, for the drafting purpose, you have to prepare 4 files. First is F1, that is DF file, that is description file. Second file is denoted by F2. Here you can see it's a figure file. And the third is claim file. Fourth is abstract file. So on description file, you have to describe, or you have to disclose everything related to your invention. Okay. And then in the second file, that is F2, in figure file, you will make, or you will paste every figures, every flowchart which is very necessary for your description file or for your invention. Third file is CF, that is claim file. In claim file, you must write at least more than 5-6 claims, so that if one or two claims are rejected in Indian IPOs, at least on the ground of 2 or 3 claims, your application will be accepted. So write as much as you can write in claims file. Last is AF file, that is abstract file. Abstract file is a short summary of your work. It is very similar to the research paper abstract. So don't go into depth related to abstract file. Next, if you are looking for a patent filing in India, you can go on this website, ipindia.gov.in. You can file application for your patent in online mode. And if you want to know more about patenting, you can join some program. You can join some workshop, short-term courses at Rajiv Gandhi National Institute of Intellectual Property Management Institute. This is situated in Nagpur. So you can go there, you can join some programs if you want to know more about the patenting. If you are looking for excellent patent application, you can go ipaustralia.gov.au. On this website, you can file your application. These are the some advantages of patents. Here you can see patent reduce the duplication of research. It also enhance the standard of research, or we can say it also enhance the technology or method of process, or in other words, we can say patent do the advancement in the methods technology. It also help industry to improve existing technology to produce cheaper and better product. It serves as an indicator for achievements in R&D institution and ability of individual researchers. So it is also a statistical indicator for any researcher, for any institution, for any R&D center. It play a very vital role during different accreditation process, for example, whether it is NAC or NBA. From the perspective of an IRF ranking, patent play a very important role for the colleagues, different colleges and universities. Okay. It's a small motivation from my side. It's the youngest patent holder. Hitesh Varshan Bhati, 9-year-old Jaipur boy. It's a physically disabled boy. He developed six-player circular chess. If this physically disabled boy can do some invention, why we are not thinking out of the box? So this is some my work is granted recently. So now concluding my today's talk by my favorite quotation. Patent is an award for the inventor and reward for the investor. So this is all about today's talk. If anyone have any doubt or any query, please feel free to ask. Anyone?
Hello.
Yes, ma'am.
Thank you, sir. Thank you so much for the wonderful session. The session was really too good.
Thank you, ma'am.
And you are always ready to support us. Whenever we need your time, you are always available. Thank you so much, sir. And the session was really wonderful. You have tried to cover everything, but the thing is that there is a little bit problem with the speaker. That's why the voice was not too much audible. But I have recorded your session so that we can listen your session later on. But the session was very good. You have tried to cover all the topics, patent applications, everything you given there. Also the examples, what all are the differences between the patent and the trademarks, and you have tried to cover how we can file our own patents also. And I think we need some support from you in the future. You are always there to support us. Thank you so much,
Sure,
sir.
ma'am.
Okay, sir.